almost all the major company and IBC matters. Now, today's webinar shall be divided into three parts. In the first part, we'll be dealing with the issue of defense of a valid dispute in respect of IBC applications filed by operational creditors. Part 2 will deal with the recent MCA notification of 24th March 2020. And the third part would be an interactive Q&A session, which should last about 15 to 20 minutes. And I request all the members, all the guests over here to submit their questions which they would like our guest speaker to answer in the chat. Now, before I hand over the session to Mr. Datta, I would request all of you to keep your mics on mute. And we've also prepared a PPT that will run simultaneously as a point of reference to the material being referred to in the session. Now, sir, I would like to hand over the session to you so that you can provide your expert views on the issues involved.
Thank you, Sonam. Thank you for your kind introduction. I hope I'm audible. That's most important.
Yes, sir.
Can everyone hear me loud and clear?
We can, sir.
Excellent. Let's start. Good afternoon, everyone. And I thank Alliance Law Group for their initiative in organizing this webinar. The subjects of discussion today are matters which are taken up, considered, and dealt with in the National Company Law Tribunal and the Appellate Tribunal practically on a daily basis. We thought we'll select a topic, and with Sonam and his team's help, we have been able to do so. A topic which is of current relevance, which is discussed every day in the courts and tribunals, and to which, in my view, there is and there can be no definitive cut and dried answer in black and white. The tests laid down by the court make it an exercise in fact-finding, in fact discussion, and every case is decided on its own facts. Now, with that background, I hope all of you are keeping safe. Look forward to the times when we are able to go back to the courts and resume normal functioning. But till then, I hope this discussion will be of relevance and help to everyone who's listening in. Thank you again. Now, with that background, let me move on straight away to the first part of our discussion, the discussion regarding the fate of operational creditors, defense of a valid dispute, trends, and case law. That's the first part of this webinar. Operational creditors, unfortunately, have been dealt with, in my view, rather shoddily in the Insolvency and Bankruptcy Code in its current form, in its current avatar. There's a larger discussion on whether their rights have effectively been defeated now. But that is for another day. Let's look at today. Let's look at the aspect of the plausible contention test as laid down by the Honorable Supreme Court. And that's the starting point of this discussion. Without going into academics, I will take you through a few decided judgments, which I think will help us understand how the courts have applied the test, the NCLT and the Appellate Tribunal have applied the test laid down by the Supreme Court in the case of Mobilox. Now, what does Supreme Court say in Mobilox? It talks about a defense. We all know in Section 9, the filing of the petition itself is preceded by a notice under Section 8, and the corporate debtor has a chance to respond to the notice, point out the existence of a dispute or the existence of legal proceedings, suit or arbitration as the case may be, or of course pay up the money in 10 days' time. If they fail to pay up the money, despite their response to the Section 8 notice, a Section 9 application is invariably lodged. In the Section 9, we all know the defenses taken are normally that there is a prior dispute existing between the parties, which is why the petition under Section 9 should not be admitted. We also know operational creditors are those creditors who provide goods and services to the corporate debtor or the alleged corporate debtor. And therefore, there is very often a case for raising a ground of a pre-existing dispute. Now, let us look at what Supreme Court says in Mobilox. Supreme Court, while outlining the procedure for filing of a Section 9, notes that this dispute that may be raised, and this is what the adjudicating authority and the appellate authority have to go into, has to be a plausible legal dispute. It has to be a plausible contention, prima facie, demonstrating that there is a tenable defense, a tenable dispute, a tenable pre-existing dispute, something which is not illusory, something which is a feeble legal defense, something which is not a feeble legal defense, something which has some basis in documented correspondence or documents exchanged between the parties, something which is not moonshine. Now, when I hear these words, one immediately thinks back to the 1956 Companies Act and winding up under the ground of inability to pay debt. Whether there was a dispute in relation to that debt was often tested by the courts on these very parameters. So the test is in that sense nothing very new. However, its application, in my humble submission, sometimes has been inconsistent, and this is what we will analyze while looking at the case law that has emerged between on the application of this test. But before that, Mobilox lays down the text. The other judgment which is of relevance of the Supreme Court is that in Insolvency. In Insolvency, Supreme Court notes that the definitions of a claim and that of a debt are relevant to determining or applying this test. We all know that a claim is defined in Section 3, subsection 6 of the IBC, and that is a right to a payment even if disputed. Please note the words, that's important. What will follow later, these words will have some relevance, even if disputed. And a debt which is defined thereafter in Section 3, subsection 11 of the IBC, talk about a right to payment of a claim. So these are the two critical sections which have come up for discussion, which have been noticed in Insolvency by the Supreme Court, form the basis for discussion of whether there is a claim and whether there is a debt or whether there is a pre-existing dispute when one looks at a Section 9 on merits, and has often been discussed in the case law that we're about to look at. Now, with that background, let us look at the examples which have emerged by way of decided cases of the Appellate Tribunal. May we have the first slide, please, on the cases. The first case that is up for discussion is the case of Hermes Travel and Cargo Private Limited. This is a case which was decided by the NCLT Mumbai bench. What is important in this case is the worth of an admission. And the admission which was found by the NCLT to weigh when it decided to admit the petition was that there was a prior correspondence between the parties, evidenced by emails, and a check of approximately 10 lakh rupees, which was sent by the corporate debtor to the operational creditor. Now, as a matter of fact, only a photocopy of that check was sent. The check itself was never sent, and therefore the Section 9 came to be filed. An argument of a pre-existing dispute was raised by the corporate debtor, negatived by the Mumbai bench of the NCLT on the ground that there was a clear admission, and this is important because one will see when we go later into the discussion that there is a little bit of an inconsistent stand on the aspect of admission. But in this case, the documentary trade between the parties and the fact that a check of in excess of 10 lakhs had been sent by the corporate debtor to the operational creditor helped the Mumbai bench of the NCLT to negative the argument that there was a dispute regarding the quantum of the debt. the petition was admitted. This case, therefore, is relevant from the aspect of an admission and the negative of an argument of a pre-existing dispute on the basis of an admission between the parties evidenced by documents. Now, we all know that admissions are looked at also in the Code of under Order 12, Rule 6, and has to be an admission based either on pleadings or on documents. That tests seem to have been applied here by the Mumbai bench of the NCLT. Maybe have the next slide now. The second matter which we will look at is that of Renewal Management Consulting versus Govind Rubber Limited, where again the operational creditor raised invoices for services which were rendered, checks were issued, checks were dishonored. The reason for dishonor was insufficient funds. The operational creditor issues a demand notice. The corporate debtor turns around and responds that there was deficiency in service, the classical defense which we hear often in all cases of operational creditors. The other important aspect in this judgment is that the corporate debtor went ahead and filed a civil suit. Immediately after service of the Section 8 notice and within the 10-day span within which it had to respond to the Section 8 notice. Again, a case before the Mumbai bench of the NCLT. The bench went into the merits of the dispute to test whether the defense raised of deficiency in service was a tenable defense or not, and came to the conclusion that the fact that checks had been issued and dishonored were adequate to defeat the argument that there was a deficiency in service. In other words, the court said, look, if indeed you had issued checks, how can you now turn around and say that there was deficiency in service? The aspect of admission once again recognized and corroborated by checks that were issued by the corporate debtor. The other important aspect was that the court also noticed that filing of a civil suit subsequent to the Section 8 notice, and this aspect has been then deliberated upon in other judgments, is no evidence of a pre-existing dispute. For a dispute to be pre-existing in the form of a litigation between the parties, that litigation has to exist prior to issuance of a Section 8 notice, and upon service, filing of a litigation is no evidence of a pre-existing dispute between the parties. Ridhima, maybe look at the third slide on this aspect. Pettis. Now, this is an important judgment. Pettis is the judgment of the Appellate Tribunal. And here, a demand notice was issued, and there were no clear admissions in the form of checks or correspondence between the parties. Nitesh Estates is a real estate company in Bangalore. Pettis would have obviously supplied services or goods to Nitesh Estates. The defense taken by Nitesh Estates was that, look, there are disputes existing between the parties. There are pre-existing disputes. Now, the Appellate Tribunal here in this judgment takes note of the Supreme Court's view in Innovative, notices the definition of a claim, in that a claim includes a right to a payment even if it is disputed, and therefore builds into its judgment this view of the Supreme Court that a claim can be a disputed claim also. One has to look at the quantum of the claim. What is the quantum of the claim? Of course, now it's slightly different, but at that time, it was 1 lakh rupees as defined by Section 4. Now, in that fact and in that background, the Appellate Tribunal reversed the view of the Bangalore NCLT, which had dismissed the Section 9, held that the dispute was only regard to quantum, firstly. Second, that a counterclaim by Nitesh Estates would not be relevant in determining whether there is a claim and consequent to the claim there is a debt payable by Nitesh Estates to Pettis and Consultants. These are two important aspects of this judgment. The view of innovative was noticed that section 3 subsection 6 and 3 subsection 11, the definitions of claim and dispute were read into this. A claim was held to include a disputed claim, and on the basis of a quantum of claim which was not in dispute more than rupees 1 lakh, the petition was admitted. As later judgments reveal, the Appellate Tribunal has gone on to say that insofar as the quantum is concerned, one will only have to look at whether the quantum is over the threshold. The threshold, of course, is different now, but then it was 1 lakh, whatever the threshold might be. And once it crosses that threshold, what is the exact quantum of the claim of the operational creditor is to be determined by the resolution applicant in exercise of powers under regulations 11, 12, 13, and so on of the CIRP regulations. Now, therefore, Pedersen becomes an important judgment. These are therefore three judgments we have taken and to examine what were the objections taken, which are typical in most cases, the existence of a litigation, the existence of a dispute, and the dispute as to the quantum, and the existence of a counterclaim. Each of these four aspects have been dealt with in these judgments, and in my humble submission, correctly so, and petitions have been admitted. Now let us look for a moment at the contrary view. The first judgment that comes up for discussion is a judgment of the Appellate Tribunal again, a recent judgment, 7th of January 2020 was the date of the decision, I believe, in this matter, in Suman Chakravarti versus Anhui Technology Import and Export Company Limited. Now here, there was a dispute. Now let's look at the facts carefully. There was a dispute regarding the quality of the goods raised by the corporate debtor in the year 2016. This was followed, and this is important, by a written communication in the year 2017 by the corporate debtor acknowledging their liability to make payments, giving a schedule, and stating how and when payments would be made. So, dispute followed by an admission. Of course, when the Section 8 notice was delivered, a defense of a pre-existing dispute was raised relying on the email of the year 2016. The petition was admitted by the Delhi bench of the NCLT, New Delhi bench of the NCLT. However, the appeal was allowed on the ground of a pre-existing dispute raised in the year 2016, and the Appellate Tribunal notices that the dispute raised was in relation to the quality of the goods, takes into account the acknowledgement of 2017, yet goes on to hold that whether or not there was a genuine dispute or not, followed by an admission in the year 2017, was a matter which could not be decided in these proceedings, in these summary proceedings. I have only one thought on this judgment, and there are a few other judgments of the tribunal and the Appellate Tribunal dealing with this issue, where there is a prior dispute followed by a subsequent admission, and an admission which is evidenced in writing, an admission which is evidenced sometimes by even checks being issued. In those cases, in my view, in my opinion, the subsequent admission has to hold the field rather than the prior dispute. The subsequent admission would only demonstrate that the prior dispute raised as a defense now is not a plausible contention, but indeed a feeble legal defense or a defense without any documentary basis, in view of the fact that a subsequent admission has been made, which would demonstrate that the prior dispute has now gone away, and therefore the corporate debtor is willing to make the payment. The next judgment on this aspect, it would be Rohini Industrial Electricals versus the National Textiles Corporation. This is also an insolvency appeal of the year 2020. The fact situation is again something that comes in more and more in operational creditor cases, is that a certain contract is executed by the operational creditor. The corporate debtor then issues a completion certificate, does not make payment either full or in part, leading to the issuance of a Section 8 notice followed by Section 9 application. The defense that is raised in these cases typically is, look, during the execution of the work, there were serious issues of deficiency of service. The goods were substandard, the services were substandard, so on and so forth. We find there could be two categories of cases in these fact scenarios. One in which post issuance of the completion certificate by the corporate debtor, there is no further communication from the corporate debtor raising any dispute. We know that typically contracts like this contain a defect liability period, during which defects, if which come to notice, are then brought to the notice of the operational creditor or the provider of services or goods as it may be, and those are then required to be rectified. Let's take the case where post the completion certificate, there are no further correspondence from the corporate debtor. Let's take a second case where post the completion certificate, there are issues, there are letters written by the corporate debtor pointing out there are disputes. In the latter, very clearly, I don't think it can be a case where a Section 9 can be admitted despite the existence of the completion certificate. However, in the first case, where a completion certificate is not followed by any other correspondence, and in this case, the corporate debtor had submitted a completion certificate in the year 2014. Unfortunately, in this case, the Section 9 application was rejected on the ground of a pre-existing dispute. In other words, disputes that arose during the execution of the contract. In my view, one will have to look at the cases, as I said, in two categories. In this case, since post the issuance of the completion certificate, there were no further disputes raised by the corporate debtor, this could not be a case where a Section 9 would not be maintainable. I can understand a case where there are issues post completion. We all know that during execution of contracts of this nature, there is correspondence back and forth between the provider of services and the person who's the owner of the project. Very often there are disputes, there are discussions, there are emails, there are hundreds of documents exchanged between the parties. Ultimately, it culminates into the completion certificate. And that is a record or an admission on the part of the corporate debtor that the work has been completed and concluded to its satisfaction. That really should be the end of the matter, provided there are no documents, as I said, post that completion certificate. Now, if we go quickly across to the next judgment, which is of Remembrance Ceremony, which again, I won't take too much time on this view, because this is a fairly standard and issue which comes up often, but the view is fairly standard. Quality of goods. The defense raised was that the goods had indeed been delivered, consumed, and no payments had been released. The Appellate Tribunal found very clearly that whether the matter was settled between the parties or whether the goods were consumed or whether part payment was released amounts to the existence of a dispute, and the Section 9 could not be entertained. The last judgment, I believe, on this aspect, which we'll quickly look at, is that of Alpha Tech Projects India Private Limited versus JMD Limited. The operational creditor here raised an invoice dated 14th of July 17, against which the corporate debtor raised an acceptance RA bill. Section 9 was filed, and the petition was dismissed. The appeal was dismissed on the ground that in 2015, and that is the evidence of the pre-existing dispute, that there were issues regarding performance and losses suffered by the operational creditor. This is broadly the conspectus. This is broadly the conspectus of the law on both sides in cases where the petition has been admitted and the petition has been rejected. These are normally the issues that come up during the course of decision of a Section 9. My emphasis is only on the aspect of an admission of a dispute followed by an admission. And that's the only aspect which I wish to point out, in my humble opinion, would be different than the judgment of the Appellate Tribunal in the matter we pointed out to all our participants now. That ends the first leg of our discussion. Instead of taking questions, if any of you have questions, instead of taking questions now at this stage, I will quickly cover the next aspect of the discussion, that is in relation to the notification that is issued under the proviso to Section 4 of the IBC very recently, whereby the threshold has been raised on 24th of March 2020 from rupees 1 lakh to rupees 1 crore. And whether, the question is a burning question today, which will soon be decided in some case or the other, whether that raising of threshold is prospective in the sense that it applies to cases which will be filed henceforth, or it will apply to all cases which have been filed, which are pending, and which have yet to be decided by the adjudicating authority or the appellate authority. While looking at and interpreting this notification, one must look at the surrounding circumstances as to what caused it to be issued. The first circumstance is the press release, which has been put out on the screen of 24th March 2020, which says that due to emerging financial distress faced by most companies on account of large-scale economic distress caused by COVID-19, it has been decided to raise the threshold of default under Section 4 of the IBC to rupees 1 crore from the existing threshold of rupees 1 lakh. This will, by and large, prevent triggering of insolvency against MSMEs. So therefore, the reason for the notification is apparent on a reading of this press release. The reason for the notification is COVID-19, nothing more, nothing less, and the distress that it will cause to MSMEs. So therefore, to prevent triggering of Section 9 applications from against MSMEs, the notification was brought about, raising the threshold. And that notification is there for everyone to see. The threshold has been raised to 1 crore rupees. Now, while interpreting it, we must look at the settled principles of interpretation of a statutory notification, such as the present one. We must take aid of two very important aspects. One would be, of course, whether this notification affects substantive rights or whether it is merely procedural, because the law to decide whether a notification or an amendment is retrospective or prospective will depend on whether the notification affects certain vested rights or it is merely procedural. The courts have held that where it is merely procedural, it can be held to be retrospective, even though it does not say it is so. Now, the second aid at interpretation is the prior notifications that have been issued under the Insolvency and Bankruptcy Code itself. We will look at two examples. In the screen that we have in front of us, on the extreme left, on your extreme left, is the current notification which we are seeking to interpret. In the middle of the screen is the Ordinance of 2019, where Section 7 was amended, to include the right to file basically against real estate companies by financial creditors, namely the home buyers, and a minimum threshold of not less than 100 such creditors or not less than 10% of the total number of creditors in the same class was included. That was a move, obviously, to protect the real estate from being attacked, real estate companies from being attacked by individuals versus a certain number of. Now, in that notification, what is important is the proviso, which points out very clearly that where an application, the second proviso, in fact, that where an application for initiating the corporate insolvency process is pending and already been filed, one will have to amend that pending application to bring it in line with the ordinance. In other words, the legislature made it clear that the ordinance will apply not only to cases which will be filed henceforth against real estate companies, but in relation to those cases also which are pending. Of course, the ordinance, as we all know, is a subject matter of challenge before the Honorable Supreme Court, and certain interim directions have been passed to ensure that the pending applications are not treated as dismissed or infructuous after crossing the deadline of 28th of January 2020. But that issue therefore remains open. But the difference between our notification of 24th of March 2020 and this ordinance of 2019 is, of course, that the ordinance itself provides that it applies to pending matters. The second aspect is the Insolvency Amendment Act of 2018, where in Section 10 of the Act, a 3C was added, incorporating a special resolution to be passed for initiation of corporate insolvency process by the corporate debtor itself. A shareholder requirement of a shareholder's resolution was built into the legislation. This was not there earlier. Earlier, a board resolution would do. Now, this did not indicate, unlike the ordinance of 2019, whether it is prospective, whether it is retrospective, whether it will apply to pending cases or whether it will only apply to future cases. This, as a matter of fact, came up for interpretation of the, there are two judgments of importance in this. One is, of course, the celebrated judgment of the Supreme Court in BCCI Kochi Club, where the test of retrospectivity has been discussed in some detail by Justice Rohinton Nariman. In the context of the IBC, of course, the Arbitration and Conciliation Act and the amendment to the Arbitration and Conciliation Act effected in 23rd of October 2015. The other judgment of importance is the judgment of the Hyderabad bench of the NCLT in Supraja Textiles Private Limited. That judgment analyzes the requirement of a shareholder's resolution as to whether it will apply to pending cases or it will apply to cases which will thereafter be filed. And on a conspectus, on a detailed reasoning, comes to the conclusion that the amendment does indeed affect vested rights, in that it includes a qualification, a threshold, a requirement, which was not there earlier, and therefore cannot be held to apply to pending cases. It can only be made applicable to future cases, cases which have not been filed. This judgment is of the, as I said, of the Hyderabad bench by Honorable Shri Bikki Rajendra Babu, who has since, I believe, retired or resigned. This was an appeal was filed against this judgment, I must tell you. Notice was issued by the Appellate Tribunal on this very aspect, whether that amendment is prospective or it will apply to pending cases. However, the appeal was not prosecuted for some reason, and possibly the matter may have been settled, and it was dismissed as for non-prosecution. Therefore, the Appellate Tribunal had no occasion, therefore, to rule on this aspect, but a view exists which can be made applicable to our case to consider whether the notification is prospective or retrospective. Now, we all know, very quickly, I'll take 2 minutes more to run through the principles for settled principles of law for interpretation of a statutory notification. We must, of course, keep in mind the fact that the Insolvency Committee, Insolvency Law Committee, as recently as in February 2020, has talked about raising the threshold provided under Section 4. They felt that the threshold for Section 7 applicants should be raised from rupees 1 lakh to rupees 50 lakhs. And for Section 9 applicants, given the fact that there are many small creditors who have been wrongly deprived of their dues, should be raised from rupees 1 lakh to rupees 5 lakhs only. So there was a view earlier also that the thresholds were too low, and they allowed people to come in and file petition after petition. Now, the other aspect would be, of course, what is a substantive versus what is procedure? What is substantive versus what is procedure? And you have a vested right in substantive and not in procedure. Whether, therefore, this notification is one which affects substantive rights is a matter which ultimately will be decided We feel it is so because it does introduce a threshold of default which was not in existence when the default happened in the pending cases which have since been filed and which are pending at the moment before the tribunal and before the appellate tribunal. So therefore, to apply this increased threshold to those cases would be to tamper with vested rights, which is relating to matters of substance, relating to substantive law, matters of substantive law, such as the right to apply, the right of appeal. These are held to be matters of substantive law versus matter of procedural right relating to, say, a forum of appeal. Where does one go for agitating a grievance? That's procedure. Do I have a right to apply? That's substance. And you have only a vested right in substance versus procedure. Limitation, for example, is held to be procedure. In Kochi Club, the Supreme Court said execution is procedure. It's not a substantive. So therefore, in our view, if we apply the principles of interpretation of the notification, according to us, the notification indeed has to be prospective. One last aspect, and I'll leave the field open for questions. A question has been raised as to the test for determining ultimately the NCLT, the adjudicating authority and the appellate authority have to determine whether there is a default or not. When is a default deemed to occur? Can it be argued that a default is deemed to occur only when it is adjudicated upon by the tribunal and the appellate tribunal, or when it gives a right to a person to institute a proceeding? In my view, one has to look at the distinction between the happening of a default, which gives the right to a party to approach the tribunal or the appellate tribunal in appeal, and the determination of default, which is the process undertaken by the tribunal and by the appellate tribunal. These are two independent things. These happen at two independent points of time, and the happening of the default is at the time when indeed the payment or the claim relating to a debt is made, not paid, leading to filing of the proceeding itself. And therefore, one can't, in my submission, argue that a default is only deemed to happen when there is adjudication by the tribunal and or by the appellate tribunal on a petition, which is then filed before it. With that background, I will leave the field now open for questions, if any that have come in, and any thoughts that the participants may have on the aspects that have come up for discussion in the webinar. Thank you, everyone, for taking the time out to listen to us.
Thanks a lot, sir, for sharing your in-depth knowledge on these two issues. I may be permitted to request Akhil, my colleague, to assist you in the Q&A session.
Surely.
Take it over from here.
Thank you, sir, for such an informative session, sir, and also sharing your valuable thoughts, sir, in so depth on the aspect of law that has not been dealt till now, sir. So now I will be reading few questions which are posed in the chat room by our fellow participants. I will read it one by one, sir. So the first question is, what are the rights of operational creditors and financial creditors for voting rights under the creditors of committee? This is the first question, sir.
The question, of course, was not discussed in the webinar, but I'll answer the question straight away. The financial creditors have voting rights in the committee of creditors, unless, of course, such financial creditors are related parties of the corporate debtors. If a financial creditor is a related party of the corporate debtor, then he or it does not have a voting right. However, operational creditors have no voting right, have no seat also normally in the committee of creditors, unless the value of the operational debt is more than 10% of the total debt of the corporate debtor, in which case the operational creditor does have a seat on the committee of creditors, but does not have a right of participation or, unfortunately, a vote in the committee of creditors. That's the position as it stands as per the law today.
Okay, sir. Sir, I just take the next question. Ms. Bhavya Singh has asked this question. What will be the impact on the MSMEs whose applications have not been admitted yet, and therefore, given the current circumstances, with barely any scope of revival, admitting their application would mean pushing them into liquidation?
If the petitions have not been admitted, then we are not talking about either insolvency or liquidation at the moment. We are only looking at whether the petition is to be admitted or not, right? Now, my view is, as I said, is that the raised threshold, the increased threshold by virtue of the 24th March notification would not apply to cases which have been filed and which are pending prior to the issuance of the notification. The reason, in my view, is very simple. The reason is that the entire basis for the notification is the COVID pandemic. If a default occurred prior to the happening of the COVID pandemic, leading to a default by a corporate debtor, then the subsequent happening of the COVID pandemic should not have a bearing on the admission of insolvency against such a corporate debtor. That's my view, but as I said, this is something which will soon be tested in the courts of law.
So Ms. Vishakha Gupta has asked these questions regarding the admission of specific Section 9 application. The purchaser of goods has raised an objection of deficiency of goods and thereafter had returned the goods to the seller. The seller has undertaken to return the entire amount if the goods are deficient, but has not so far. Would a Section 9 application filed by the purchaser for the amount against the returned goods be maintainable?
Well, if the goods had so far not been returned, it would be evidence of the fact that the goods have been retained and have been found to be defect-free. However, if there is a period during which the goods have to be returned, and contractually agreed period during which the goods may be returned, then one may have to wait for that period to be over in order to claim a right to file a Section 9 application. Because someone may argue that, look, I have another 1 month left to go, and therefore I may have a right to return the goods during that 1 month if I find that there are issues with them. That may be the answer, but it will depend largely on the facts of the case. The terms of the contract, the documents exchanged between the parties. Unfortunately, in Section 9 applications, there is no black and white. One will have to look at the correspondence between the parties, the terms of the arrangement, and then come to a conclusion whether there is a default or there is a pre-existing debt.
So Manya Chandok has asked this question. The onus of proof was much higher under the winding up provisions when a creditor could drag a company into liquidation due to their inability to pay debt. So do you think IBC should also draw from there while assessing default?
Well, Manya, I think you are right. And I think the threshold which is now being examined or which has now been put in place by the tribunal and by the Appellate Tribunal in Section 9 is practically as high, if not higher, than the threshold which was existing in relation to winding up matters under the 1956 Act. We have looked at the case law. Any hint of a dispute, and this is important, any hint of a dispute between the parties evidenced by some correspondence has been treated as adequate by the adjudicating authority and by the appellate authority to dismiss a Section 9 application, which is why we took pains to look at case law where we have tried to show that existence of an admission by virtue of correspondence, by virtue of issuance of checks, or even a photocopy of a check being sent by email should be enough to defeat the argument of an existence of a dispute. As we all know, these are contracts of goods and services. This is not a loan, which is very easy to demonstrate, and a default in relation to a loan in a Section 7 scenario, very easy to demonstrate. These are, as I said, contracts for goods and services where there is a lot of scope, a lot of correspondence between the parties to raise an argument of an existence of a dispute. Threshold is as high, according to me.
Okay, sir. So Shishi Kaul has asked this question. With the government considering the suspension of the provisions of IBC for 6 months, what will be the impact of this notification and also the future of IBC?
Okay, so the future of the IBC, of course, will depend on the language of the ordinance. If indeed Section 7, 9, and 10 are suspended, as we all expect them to be for some length of time, whether it's 6 months or 8 months or 1 year, fresh cases obviously would not be filed. But I am sure that there is enough work left in the tribunal and the appellate tribunal to occupy them for the 6 months or 9 months or even a year, if you ask me, to take care of the existing cases. We often complain as lawyers that apart from IBC, No other cases are being taken up and heard by the tribunal and by the appellate tribunal. Company law matters in relation to operation mismanagement, company law matters relating to mergers and acquisitions, amalgamation schemes, etc., are not being heard. Well, this is the time to get all that heard. So far as IBC is concerned, it's here for the long run. It's not going to go away anywhere. The provisions may be suspended given the fact of the extraordinary circumstances that exist today, but I'm sure we will be back with the bang very soon.
Right, sir.
Right, sir. So next question is, so much emphasis is given to pre-existing dispute, and rightly so. But what will be the scope of genuine dispute raised after the Section 8 notice?
The law as it stands today, unfortunately, will not countenance that defense to be genuine, for the simple reason that it has never been raised prior to the issuance of a notice. That's the law as it stands today, and I think that's correct. Because if you have supplied goods, if you have provided services 1 month, 2 months, 2 years back, and you have chosen not to comment on the goods provided or the services rendered till a Section 8 notice is raised, then indeed the assumption, and I think that's a fair assumption to take in law, is that you had no difficulty with the goods provided or the services rendered. You are now trying to raise a bogey once a Section 8 notice has been issued. Whether that dispute will be genuine can only be then traced back to an earlier document between the parties, to earlier correspondence, to earlier conduct of the parties, which would show that there was a dispute prior to issuance of a Section 8.
So Ms. Vishakha has also sent one more question, where a party to a master service contract has initiated arbitration, but before filing of a statement of defense, the same party files Section 9 application. Would the arbitration initiated by OC prior to Section 9 application constitute pre-existing dispute? So further, would the situation be different if a statement of defense / counterclaim has been preferred by the CD prior to the Section 9 application?
No, Vishakha, the second aspect of the question that you have raised is the statement of defense, if it is filed in the arbitration proceedings prior to or post issuance of the Section 8 notice. If a statement of defense is filed prior to the issuance of a Section 8 notice, pointing out that there are issues, the deficiency of service or quality of goods, etc., and therefore there are pre-existing disputes, that may be an answer to the Section 9 application which is filed subsequently. Now, the mere existence of an arbitration agreement or the arbitration proceeding would not be enough to defeat a Section 9 application. So this is the remedy given under the IBC is an independent overriding statutory remedy. And the argument which is raised in courts and which have been successfully countenanced is that whether that arbitration law remedy is a private law remedy for recovery of money and other contractual reliefs, whereas a relief under the IBC is a relief nothing to do with recovery. It's a relief for insolvency resolution or for liquidation of someone who's unable to pay dues. So therefore, two independent remedies, one a private law remedy, one a public law remedy, a statutory remedy. And statement of defense pre-Section 8 may have a bearing on the Section 9, but post-Section 8 will not have a bearing on the Section 9. And the existence of the arbitration itself will not be a bar to initiation of the Section 9.
Sir. So Ms. Gitika has asked this question, will the dispute raised after the transfer of winding up petition to NCLT and before sending Section 8 notice by the operational creditor be considered as an existence of dispute?
Now, this is a question to which, according to me, there is no direct, clear answer as yet, unfortunately. In matters which are transferred from the High Court to the NCLT is often asked, in the case of an operational dispute, do the operational creditor to send a Section 8 notice and thereafter to file the petition again. Now, if that be the case, then once prior to issuance of a Section 8 notice, if someone raises a dispute, then there'll be an issue, certainly. However, if a Section 8 notice is sent and there is no prior dispute, then of course the petition will proceed for admission.
So Mr. Bhuvan has asked this question, if an OC has rendered services to CD at 3 different projects and only in one project there is a dispute, will that tantamount to a dispute if CC claims it demand based on only two sides and not the third one?
No, is the question therefore whether the corporate insolvency will be project wise or in relation to the corporate debtor?
I just repeated once.
Possibly that's the question, I think.
Yes, sir. If an OC has rendered services to CD at 3 different projects and only in one project there is a dispute, will that tantamount to a dispute claiming its demand based on only two sides and not the third one?
Okay, so let's look at the example that has been given. Services rendered at 3 sites, dispute only at 1 site. Now, if there is no dispute regarding the other 2 sites and the quantum of outstanding in relation to the other 2 sites is more than rupees 1 lakh or rupees 1 crore as the case may be, then of course the section 9 will be admitted. Because as we looked at Pettis, that's why we looked at Pettis closely, which said that the quantum, if it is more than 1 lakh, if part of your claim is disputed, but the quantum is more than 1 lakh, then the petition itself should be admitted.
So there's another question. What is your view on the issue with respect to joint filing of application under section 9 by OC, once again left out by legislation, whilst increasing the pecuniary jurisdiction to 1 crore as contrast to financial creditors application under section 7 of the code?
Yes, I think that question was from Abhishek.
Right.
At the moment, it is only the rules provide that a section 7 application can be filed by 1 or more creditors. So far as the section 9 application is concerned, it cannot be filed, it seems, at the moment by more than 1 creditor. However, in relation to real estate projects, Abhishek, we have seen that joint insolvency is being allowed in relation to 2 companies, which are, say, a joint venture company. So a respondent can be more than 1 in the case of a joint venture company. However, in the case of an operational creditor, unfortunately, today, the rules or the act does not provide leeway to more than 1 operational creditor to launch a section 9 application.
Okay, sir. So there are a few more questions, but due to paucity of time, it will not be possible to take each and every question, sir.
Oh,
therefore, sir, I will be posting our official email ID in the chat room so that whomsoever has any query or questions related to the subject matter can contact us directly. Afterwards, with coordinating with you, we will try to respond as soon as possible, sir.
Thank you very much, everyone, for your interaction, for your questions. And we hope to have a session soon to discuss further. IBC is a vast field of law. It's a new legislation. It is dynamic. It is evolving every day, every week as we go on. So we hope to be back soon with another session.
Yes,
thank you, everyone.
So now
thank you, sir. Yes, sir. With the end of the with the end of this robust and interactive question and answer session, we end our webinar. First and foremost, I would like to thank our audience for being wonderful. And most importantly, sir, thank you so much for enlightening us with your knowledge on the subject. I would also like to thank my team comprising of a partner, Mr. Sonam Sharma, our associate, Mr. Akhila Sija, associate, Mr. Pranoy Chatterjee, and I for getting this webinar all together. If there is any feedback that the viewers would like to give to us, please post on our Facebook page or write an email to us on mail@alliancelawgroup.in. Towards the end, I would also like to end by giving introduction to our next webinar, which would be relating to the environmental laws, given the current circumstances that we are living in. So we'd soon be back with that. And I would request you to check our Facebook page for updates on the same. And in case you have missed out on the beginning of this webinar, the recorded version is available on our Facebook page. Once again, thank you so much, sir.
Thank you, Alliance Law Group. Without your help, it wouldn't have been possible. Thank you.
Thank you very much. Thank you.